Welcome to the Hughes Hubbard Anti-Corruption and Internal Investigation Practice Group's podcast, All Things Investigations. The Hughes Hubbard Anti-Corruption and Internal Investigation Practices Group represents many of the premier companies around the world, providing advice on issues spanning the full anti-corruption and compliance spectrum. In this podcast, host Tom Fox and members of the Hughes Hubbard Anti-Corruption and Internal Practice Group will highlight some of the key legal issues involved in white-collar and other investigations, both domestically and internationally. We will tackle topical issues involved in investigations, as well as explore how companies can prevent and detect issues that arise in conducting investigations on a worldwide basis. Hello, everyone. This is Tom Fox back again with another episode of the award-winning All Things Investigation. Today, I'm absolutely thrilled to be joined by Mike DeBernardis and Shayda Vance. Shayda, first of all, welcome and thank you so much for joining Mike and I on this podcast.
Thank you. Thank you for having me.
Shayda, our audience has met Mike before on prior podcasts, but this is your first. So could I ask you to tell us a little bit about your educational background and the nature of your current practice at HHR?
Sure. So I went to law school at Columbia Law School, so in New York City. I was a big fan of the city, and I miss it quite a lot. I'm now in Washington, D.C., which is wonderful. I work with Mike at Hughes Hubbard's Washington, D.C. office, and I'm in the investigations group together with Mike. I also do some international arbitration work and some litigation, domestic litigation here in the U.S.
Great. So we're going to visit today about the Austal plea agreement. It's a really interesting case. And Shayda, could I just follow up with you and ask you to tell us about the facts of this case, and we'll go into some lessons learned.
Sure. So Austal USA is a shipbuilding company. It's a subsidiary of Austal Limited, which is an Australian company. So Austal USA builds ships for the U.S. Navy. So one of these ships, it's called the Littoral Combat Ship. It's a LCS, is what they call it. In the making of these ships, Austal was misreporting the costs of making these ships. And so it was overestimating the profit of those ships in its financial records. So this was happening for about 3.5 years, mostly through 3 executives of the company who were misreporting this information. And so the DOJ brought 1 count of securities fraud and 1 count of obstruction of federal audit against the company. Those 3 executives were also separately charged, and their trials are upcoming. In addition, the SEC has brought violations against the company for violations of anti-fraud provisions of the Securities Exchange Act. In August 26th, the company entered a plea agreement together with the DOJ and the SEC for $24 million. There will also be an independent compliance monitor for a period of 3 years, and the company will have to serve 3 years of probation. They did receive some credit for their cooperation with the investigation. And of course, they've agreed to cooperate with any further investigation from the government and to try to implement a more robust compliance and ethics program going forward. So that's kind of just briefly a summary of the facts.
So there's a lot to unpack in there in terms of either analysis or lesson learned. And Mike, if maybe I could start with you, is what do you do when the senior execs are in on the fraud and actively trying to forestall anyone taking a deep dive and figuring it out?
Yeah, it's a great point. And I think for me, certainly one of the major lessons or takeaways here, because as Shayda mentioned, also did receive some credit for cooperation. I think ultimately it was 5% off the bottom of the sentencing guideline ranges, the credit they received. But if you read between the leaves in the plea agreement, there was certainly some dissatisfaction with both the cooperation and the remediation, at least at the early stages of the government's investigation. One of the things that the DOJ pointed out was, although Austal has taken some steps to remediate the misconduct, it was ultimately, in their view, some of it was untimely, including the fact that it took Austal, I think, at least 2 years from the time that the government started its investigation to take employment action against the individuals involved, What it doesn't highlight is the fact that the individuals involved were three or four of the most senior people at the company, and that taking employment action against those individuals is, in the best of circumstances, a very difficult process, right? Not just because you have to get the right level of seniority in place to take that action, but because you can't just terminate your CFO, president, head of a program all at the same time without a sort of successor in place. There are those risks involved. I think one of the things it highlights is, especially when you're doing an investigation, you have an allegation involving the most senior people at the company. And that can be someone in the C-suite. It doesn't have to be all of them, but we're talking about high-level executives. It's really important, in my view, to get a direct line to the board of directors in the connection with the investigation. Sometimes that might mean creating a special committee of the board to oversee the investigation. It might mean just direct reporting to the audit committee. But certainly from an appearance standpoint, and to ensure you are maintaining your independence in the investigation, you want reporting outside of the structure of those individuals who are potentially implicated. But then certainly if you need to take action against the individuals, you need a body who has the authority to do. And really, when you're talking about the president of the company, the only body who has authority to take employment action is the board. So having that direct line of communication can be critical.
So with that, Mike, how do you think or I guess maybe Shayda, what are some of the considerations for government contractors, not necessarily after the fraud occurs, but how do they put a plan in place? Is it a compliance program? Is it, as Mike has suggested, really start with the board who has oversight and visibility? How would you suggest they think through getting ready for this eventuality?
Yeah, so I think certainly a compliance program, a robust compliance program is very important. And then maintaining kind of regular checks on that program, making sure that it's current, making sure that you're taking into consideration any new regulations that have been passed. I think also maintaining a good relationship with your client, with the US government throughout this process, and maintaining a line of communication is very important. In this particular case, Austal was in a position where they knew the fraud had occurred, they knew these charges were coming, and they began conversations with the US Navy to maintain their status as a contractor. And that's hard to do if you don't have those lines of communication or that good relationship. So they have, my understanding is that they've entered an administrative agreement with the US Navy, and that those conversations have been happening in parallel with the conversations with the DOJ and the SEC. So that's important for the company to continue doing the work it's doing, to continue getting contracts with the government going forward.
Yeah, and I think just to add on top of that, Shayda, it's a really good point, because in a lot of ways, this is sort of a meat and potatoes securities fraud, right? They falsified their expenses to boost their profit so that the stock stayed high, so that the executives could get their bonuses and options and everything. And it's as old as time, highlighted by some of Tom's favorite cases, and Enron and WorldCom and those, but very basic type of securities fraud. I think here what's interesting is that it happened for not just a government contractor, but a U.S. defense contractor. And the reality is the fine is serious. They had to get the fine. They had to get a reduction for inability to pay, but still the fine is what it is, and it's very serious. But what would have been far more serious would have been a finding by the Navy that Austal USA was no longer a presently responsible contractor and ineligible for Navy contracts. That, in theory, could have really ended the company, at least Austal USA, as it existed. So I really credit to the team at Austal, frankly, and their counsel for being proactive in that regard and making sure that was a primary consideration as they were going through this process.
Mm-hmm.
Mike, you talked about the reading between the lines. You saw a little concern with the lack of cooperation, or at least slowly moving towards cooperation. And I would like to remind our listeners that cooperation is credited in two ways. The first is if there can be a reduction and your overall scoring for your fine and penalty under the Corporate Sentencing Act. Also, there can be an additional reduction, as you mentioned, Mike, of 5%. If you don't cooperate or you slow walk that cooperation, it can literally cost you millions of dollars. It didn't in this case, but we've seen other examples where that failure to come to Jesus or get religion or at least get with the program cooperation literally has cost tens of millions of dollars. So I want companies to understand that there's real incentive from the Department of Justice. But Mike, what do you think it communicates to the DOJ if lawyers or a company sitting across the table from them and the DOJ frankly thinks it's less than full cooperation? Does that really lead to or perhaps create a lack of trust, which then bleeds into other areas? Could you maybe comment about that part of cooperation?
Yeah, for sure. And it's a good point. And you're right. We, as Tom, when you and I talk, we often do the calculation and say if they got an additional 5% for cooperation, it could have saved them X number of dollars. But to your point, I think the cooperation credit goes beyond that, and the sort of discussions you have in these contexts where credibility is critically important. And so it's, in my view, not just cooperation, right? Because there is space to push back on requests and to not just hand over absolutely everything and do absolutely everything that the government is requesting. But it is building a credibility, providing reasonable, sometimes extraordinary cooperation. And when you are sort of pushing back or deciding not to provide what the government is requesting, having really a reasonable justification for that, whether it's this is going to take time because it's burdensome, whether that's outside of the scope of this particular investigation, we need additional facts, whether that's outside of our particular control, we don't have that information, or whatever it might be, to be sure that it doesn't appear that you are just trying to stonewall the investigation. In my experience, stonewalling the investigation is very rarely a successful strategy, or if ever, frankly. So it really goes to the credibility, which comes into play throughout, right? This is a long process. And so if you lose credibility early, it can be difficult to get it back, even if you're able to sort of get some of the cooperation credit back, which it appears they did. In this case, it's hard. Again, we're reading the charging documents. We're not involved in this matter, so we don't know all the facts, but it struck me that the plea agreement points out that cooperation appeared to increase 2 years after the investigation was started, which happened to coincide with the same time that these executives were terminated. So it's possible there was a correlation there, and that some of the initial reluctance and maybe lack of cooperation was a result of the individuals involved.
I also wanted to maybe explore another point. I think you, Mike, raised this, which is if you literally lop off the top 3 executives from any corporation, it's not that there's going to be repercussions. It's that you have lost a wealth of knowledge of how to run your business. And certainly you can bring in seasoned executives from a wide variety of sources who may be very good, but they're not going to have that institutional knowledge. It's going to take them some amount of time to get up to speed. You're in the middle of a crisis mode anyway, because you're under investigation. You may be facing a robust penalty and or resolution in the form of some sort of deferred prosecution agreement or other agreement, which will put a monitor over you. And I really it just struck me the way you phrased that. I hadn't thought through what that could mean to a corporation, as you don't want this to happen. It's one thing to pay a fine and penalty. It's another thing to lose your entire executive leadership team.
Yeah, maybe I'm curious Shayda's thoughts on this, but I just want to pile on there because we're also talking about an industry and a company that is working on some of the most complex warships in the world for a client with a mandate that's talking about global security. Missing deadlines and that sort of thing can sort of have catastrophic consequences. Really, we talk about crisis management often, and this is about as high of a crisis as you can possibly imagine. But Shayda, I don't know, what do you think? I mean, what's a company to do in these circumstances when you have some of your most senior executives that you might have to replace? I mean, what's sort of a strategy there?
Yeah. Yeah, no, and just to add on to that, I think one of the three executives here was the director of the LCS program. So you're talking about someone with a lot of technical expertise on the ships that were involved. I think where possible, promoting internally is always helpful, right? If there's someone who's there, who knows the ropes, who's been working at the top, but just below that tier, that I think makes a lot of sense. To the extent that is possible, I think that can help a lot with continuity. Sometimes, though, it does help to have a fresh face, right? Someone outside of the company who can come and kind of right the ship, in which case you'll just want to make sure that they have a lot of internal support and get up to speed as quickly as possible. But it's a challenge. I don't think there's an easy way to make that transition.
Jade, I'd like to pick up on a phrase you used, which is not presently responsible. Many of the listeners to this podcast are compliance professionals, but they may not be familiar with that term. It's a highly significant term in U.S. government contracting. And I was wondering if you might be able to, for us lay people, explain what that might mean and how the significance of that term, if there is such a finding.
Right. So I think Mike actually used this term. So so my understanding is that it's linked to whether or not a contractor can continue to work for the U.S. government. So it's really key. It's a key finding to ensure that a company can continue working on U.S. contracts going forward, which is kind of linked to what Mike was talking about a little bit earlier.
Yeah, and it as Shayda and I have advised companies, it can be affected by a number of things, including certain criminal violations. Of fraud is one, corruption is another one, and so it's why some of these cases that are always significant for companies take on just an added layer of significance and seriousness when you're talking about a government contractor. And then to me personally, I think even an added layer of seriousness when you're talking about a defense contractor, because the Department of Defense is not easy with this type of thing and has sanctions and departments officers who are very serious about it, suspension of department officers.
There's one other point in this case, and I really want to say a few words about it and its significance, and that is that Austal USA was listed on the American Deposit Registry, or ADR. And that didn't really play, I think, to the jurisdiction of this case, although clearly it was important to the SEC because they mentioned that in the order. And Mike and Shayda, I often wonder about foreign companies that do business somehow in the U.S., or in some way, I should say, and they think they get something from ADRs. What they forget is they've gotten U.S. jurisdiction. Mm-hmm. So could either of you say a few words about ADRs? And if you don't know if you have an ADR, please go look. That's all I ask.
Yeah, for sure. I think I'm going to get out over my skis if I talk too much about the financial benefits of it. But opening yourself to the U.S. market is obviously can be beneficial from a financial perspective in terms of raising capital. And so I think a lot of companies are intrigued by that possibility, right? Intrigued by offering ADRs on U.S. exchanges. And now we have a whole set of wealthy, whether it's pension funds, individuals, whatever, who can contribute capital to our company. It comes with a lot of regulation, to your point, Tom, and a lot of jurisdiction, not just regulation, because I think, of course, you expect that you're going to be, if you're trading in the U.S., you're going to be subject to SEC rules. But now all of a sudden you're under FCPA jurisdiction, even if your conduct is completely outside the U.S. and all these other things. It's a trade-off. I think a lot of companies, when they make the decision to list ADRs, they're not thinking about avoiding U.S. jurisdiction. They're probably hoping never to have to encounter that. But it's certainly a trade-off. And I do know, to your point, companies around the world who would not consider doing it simply because they would never want to subject themselves to U.S. jurisdiction, in certain countries in particular. But Shayda, what do you think?
Yeah, no, I agree. I think there's definitely a trade-off. I mean, hopefully, like you said, I think one hopes that you would never violate any of the U.S. regulations and it should be a non-issue. But it's certainly something to be aware of and to ensure that the company is doing everything it can to remain in compliance, right, to avoid these kinds of fines. Yeah.
Guys, fortunately, we are near the end of our time for this episode, but I wanted to thank you both for bringing this case to my attention. It is a little bit outside of what we've talked about on other episodes, but I think there's quite a lot of lessons for every compliance professional and indeed corporate executive and even board member to learn from this case. So kudos for bringing it, and can't wait to see what we come up with next.
Thanks for having us, Tom.
Thanks, Tom.
This is Tom Fox again. Thank you so much for listening to this episode of the award-winning All Things Investigations. If you've enjoyed this episode, I hope you'll subscribe, rate, and review wherever great podcasts are listened to. All Things Investigation is a production of the Compliance Podcast Network.